Welcome back to the Law and Crime Network. Law and Crime Report is with you right now. I'm your host, Bob Bianchi. We've got some great topics and great guests slated for you today. We're going to start off with Jacob Blake, and then we're going to move into Michelle Troconis and the developments that have occurred in that case, as well as George Floyd. R. Kelly is in the news, looking to be released from prison, and a $4.65 million settlement in a jail case where an individual was seriously injured and paralyzed. But first, let's go to Jacob Blake's father to listen to him talk about what happened to his son while he was in the hospital.
I know there's a lot of parents out here in this crowd. You cannot imagine what it feels like to look at your baby paralyzed from the waist down, shackled. Where was my son going? They already put him in the bed.
All right, Julio Rosas is a townhall.com senior writer, and Linda Kenny Bodden, host of the Law and Crime Network and All Things Extraordinary in the Criminal Law World. Welcome to the show, guys.
Thank you, Bob.
Yeah, Julio, listen, just real brief. We're going to talk about this handcuff situation in a minute. There have been some recent developments. I think there's a Washington Post article that's out there. It's very detailed with regard to facts that what precipitated this incident. Some information the public may not know as to why the officers engaged in the encounter in the way they did. Can you give us an update?
Yeah, so basically, I mean, the reason why the officers were called was because allegedly Blake stole a woman's car keys, and this woman was supposedly a victim of his in a sexual misconduct encounter. And so that's kind of reason why that was the whole situation kind of evolved out of that. And so initially, the initial report said that Blake was trying to separate these two women from fighting, and that's why they were wrongfully, racially profiled him or what have you. But we also do know from witnesses that two tasers were used from both officers, and for whatever reason, that didn't work. And so it then led to, and then the Wisconsin DOJ said that he did have a knife in the car. It did not specify whether he was reaching for it or whether it was close by when the officer shot him. So a lot of this new information is coming out, and unfortunately there was a reaction to it that resulted in riots before all that information came out, and more still needed to be known about this case.
Right. I believe that if I read it correctly, you correct me if I'm wrong, that there may have been arrest warrants that were outstanding. There was a protective order which precipitated this encounter with the person where he's not supposed to be around. He was not following officer commands. Tasers were used and they were ineffective. He continues to not obey officer commands, gets into the car. One of the officers is heard yelling, drop the knife, and the shots went off. Is that about an accurate account of what you know from the facts so far?
Right. And when the officers were dispatched, they were informed that there was a warrant that was still outstanding for his arrest. So they knew that this person, that Jacob Blake had a pretty extensive criminal background. And so that's not to say that's justifiably shoot him in the back 7 times, but there's just so much background to this case that was just from that first video that was published on social media on Sunday.
Yeah, Linda Kenny Bodden, as a former assistant prosecutor and currently a defense lawyer now, I'm going to ask you to put your defense lawyer hat on for a moment. Officer training and escalation of force, I'm going to ask you, will that be admitted into evidence? In other words, officers are trained to use verbal commands. They're trained to then escalate to non-lethal force. If that's not listened to and they believe that there's a possibility of lethality, they're allowed to use lethal force as well. And I'm just asking your opinion as a defense lawyer. How do you go about defending the idea that there is yelling going on, drop the knife, and I understand the optics of being shot in the back, but would you be defending this saying he could turn around in a heartbeat, he's not listening to officer commands, he's already not been tased down, and he now grabs a knife, and that they were in fear of their lives? Is that a defense in this case?
Well, that's going to be the defense, Bob. But, there's a case called Tennessee versus Garner. You don't use deadly force against somebody that's not giving you deadly force. I mean, the knife was under the floorboards of the driver's seat in the car. And the officers apparently asked him if he had a weapon, and he told them he had a knife in the car. I mean, this is, we can talk about this, but I really think that to put out there that this is that this could possibly be justified, even if that's going to be the defense, really is a misservice to what we're trying to do here,
I
which
know
is
what I'm
justice.
trying to do, Linda, is to get a defense here. And the second thing I'm trying to explain is that these officers are trained prior on the range. I've gone through the training, and they go through training about individuals with knives. And what they are trained is that somebody can close the gap with a knife, even if they're 18 feet away, within 2 or 3 steps in seconds. Here, this officer is right on top of him. They're trained on situations just like this, that someone can turn around and stab you. And if they're not listening to commands, this is how they're trained. I'm not trying to justify it. I'm just trying to get from the Law and Crime Network what the defense will produce and whether or not it's valid. What if the officer doesn't do something? Is it possible in your mind? Possible. He could turn around with that knife and stab the officer. Is it possible?
Yeah, yeah. Here's the problem, though, Bob. If the officer makes it up that he doesn't have a knife, and then just saying that so he can shoot him, that's a problem, and we've seen that. Is that going to be the defense? Sure, that's going to be the defense. I mean, there is no other defense here, and then we see that across the nation. But if the officer says, and we've heard this in many cases, drop the gun, drop the knife, and it turns out they're saying that, or stop resisting is usually the normal one. Stop resisting, right? In terms that they're saying that to give themselves some justification to do what they're going to do anyhow, that's a problem. So if you're a defense attorney and your client comes to you with that, you've got to sit down sometimes and have a come to Jesus talk with the client too. But that will be the defense, of course.
And just for a note, I mean, from the reporting, and this is one of the problems that we have. We don't have the investigative file, so we have to do it just by what is reported. It is reported that he had admitted that, in fact, he did have the knife. Whether that, in fact, is accurate or not, we will see down the road. Thank you guys very much. I appreciate those opinions. The press conference was held by the Kenosha Police Department, where reporters were asking specifically why it was that Jacob Blake, who had been shot 5 times in the back and was paralyzed, was handcuffed to a hospital bed. Let's take a listen.
To have an outside investigation in place, it's also very helpful, obviously, to have an outside agency guard that person for his protection and for liability reasons for the department. He's being guarded because he's under arrest, and yeah, it was for an outstanding warrant for 3rd-degree sexual assault.
And a follow-up question, if I may. Can you tell us if the officers who responded to that call on Sunday knew of the outstanding warrant?
I can't speak. I believe that's why they were there, but I don't know specifically.
Linda, let me go to you first on this. Based on your experience as an assistant prosecutor and a defense attorney, how customary is or isn't it that an individual who is under arrest in a hospital is handcuffed to a bed?
Yeah, it's very normal. I had a client that actually was in an accident and had a fractured cervical spine from the accident, and it was handcuffed. But after the medical personnel intervened and the police intervened and we intervened, they did unhandcuff him from the bed. So it can be done. It's within the discretion of the department at that point. And also, you have to have a little common sense. If he's paralyzed, he's not going to be doing anything. If he's sedated to the point where he can barely move, he's not going to be doing anything. But it usually is a customary thing that if somebody's arrested until they are arraigned, and here the problem is that there was no arraignment date set. In New York City, you're arraigned, boop, 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 right there, right in the courtroom in Bellevue.
Yeah, Linda, I mean, again, I go back to like how police are trained and police culture. And if people want to start talking about police reform, which I was a huge proponent of, and we succeeded, I think, greatly. I was very proud of that and became part of an attorney general's task force because of the work we did when I was county prosecutor. But I know cops and I know how they are. They're very policy driven. I'm not saying all cops are right, or I'm not making an assessment. But when they're told, you don't give a lot of discretion in policies like whether you handcuff a prisoner or you don't. It's up to you. Take a look at his medical records. What do you think? Those are things cops hate. Like, I used to laugh kiddingly, and I love my police friends, but don't get me wrong. When the lawyers would leave my office, I'd say, okay, you can go, and they would just walk out the door. The cops would always, a cop would ask you, should I use my right hand to turn the doorknob or my left hand to turn the doorknob? And I'm only using that facetiously to say they follow protocols and they just despise. I'm talking about the good cops, despise breaching those protocols. So what does a cop do? I'm sure this wasn't a senior person. This is probably one of the lowest guys on the totem pole that's there sitting there guarding a person that's in a hospital.
Yeah, but he's been now he was there for a couple days before this became known out into the media. So I mean, really, the medical personnel always say, "Can't you release those handcuffs? We're trying to treat him, especially if you have to turn him over, you have to give shots, you have to give good medical care." So I mean, really, unless it has come to the forefront, Bob, of the media, the handcuffs would still be on him, and that's the problem here. We have to start tempering what we do and how we treat people, whether they're in the hospital, whether they're, what their crime is, and whether or not they're paralyzed to be able to determine whether or not we should keep those handcuffs on.
Hate to talk about stories, but have had a couple of cases, both as an EMT and as a lawyer, where somebody was in an unconscious state under arrest, and the individual came to. One person was in a semi-coma, and one actually very greatly assaulted a nurse because they weren't restrained. I'm just saying there's two sides to the story. Jake, sorry, Julio, tell us out there, what is the feeling about this handcuff scenario? Is it just salt in the wound to those folks out there? Are they listening to law enforcement with respect to the reasons they're saying what they're doing? Or are they just not buying it?
Yeah, so when I was in Kenosha this past week, that the family, when they had one of their first press conferences, they did make it a point to point out that Blake was still handcuffed, and they were saying that that was totally unreasonable because he's paralyzed. They were saying, what more can he do? And so, no, yeah, to them it was definitely assault in the wounds type situation, and because I mean he had extensive damage to his kidneys, his colon had to be removed, he had holes in his stomach, and so to them he's saying he wasn't a threat before. He's definitely not a threat now. So why is he being handcuffed? That's what they were saying, and so you can imagine that really inflamed some more anger not to law enforcement in general in Kenosha, and then unfortunately there were some more riots later that night, and so it was not not at all well received when
Yeah.
people found out that information.
Well, you're doing excellent reporting. We really appreciate it. Julio Rosas, thank you so much. And please come back again.
Thank you for having me.
Okay, great. Awesome, guys. We got a lot more on the plate here and another new guest coming up after the break. We'll be right back. All right, welcome back to the Law and Crime Report. My name is Bob Bianchi. So let's move on to George Floyd. Okay, former officer J. Alexander Kang has filed a motion to dismiss the charges against him. I believe he's the second officer now that has actually done that. And we have Mike Corbanix and Linda Kenny Bodden with us. Guys, essentially, this reads to me kind of similar to Officer Tao. Officer Tao actually used a description that I was just a human cone, C-O-N-E. I was keeping the crowd back. I didn't share an intent with Chauvin to commit a murder, and I want the charges dismissed based on a lack of probable cause. So, Mike, let me go to you first to just try to explain to our audience what kind of motion this is and how difficult it is at this stage of the case to get that motion granted, and essentially what your thoughts are about the validity of the motion.
I'm not a big fan of these motions, and I know defense attorneys will disagree on whether or not to file them or not, and I think they're very fact specific to the case. It's a very low threshold for the state to come over because it's probable cause. It's a reasonable suspicion. I don't like it from a defense tactical point of view because what it does is it gives the state or the prosecution an opportunity to strengthen their case because you're pointing out weaknesses to it, as opposed to just attacking and defending your case once a jury is sworn and jeopardy attaches. A motion is early, there's no jeopardy attaching, so they could strengthen their case by the flaws you're showing it. And when I say jeopardy attaching is once the jury's sworn and you're acquitted, you can't be tried again. You win the motion here and they come back, you could still be tried.
Linda, going back to the points that we were making before in the previous segments, do you think that this is at least the defense's attempt to get some information and data out to the public? Not really suspecting that they're going to win this motion, but they're showing that they're fighting and they want their side out there. We are talking about jury pools here.
Well, Bob, let me first say to disclose, as many people know, that my husband, Dr. Michael Bodden, did the second autopsy on George Floyd for the family. So I just want to disclose that. Now, speaking as a defense attorney, I'm torn here. Okay, forget the case. Forget that this is the George Floyd case. Okay, the more I put this stuff in the news by making these motions, the more it's in the news, right?
Mhm.
I want to be flatlined here. I want nothing reported on this until I have to go pick a jury. I don't want anyone to consider and talk about this anymore for a while. I want to have the jurors, people out there who are the jury pool, forget it. By the same token, there may be requirements in the practice of this state that says you have to file certain motions within a certain period of time, and then you may have to do it because or else if you lose the case, your appellate attorney is going to argue attorney malpractice. So I'm torn on those issues, Bob. I don't know where I'd have to come down if I were in the state and knew what the rules were.
Yeah, and a lot of people, it's a great point, don't realize the nuanced tactical decisions lawyers have to make and balance throughout the case at each and every stage of it. We have a clip from mid-July of Chris Stewart and Ben Crump, who are representing the Floyd family, speaking of the family, saying what these charges represent. Here's Chris Stewart, the attorney for the family.
It's very important, that question that was asked is, do we have to fight this case, for years and years and years? The answer to that is no. This case could be resolved in 30 days if city council and the mayor wanted it to be. It's about what do they care and how do they envision George Floyd. It's simple as that. I've had some that have resolved in 60 days or 30 days because they cared about the case. I've had some that have taken 4 or 5 years because they knew that they can outweight all of the media and outweight all the protesters, and you'll be gone in a few years. So it's really about who your elected officials are and what they care about.
We've been working nonstop day and night on this case in Minneapolis and outside of Minneapolis. In fact, giving testimony before Congress and talking with the senators and so forth to achieve real systematic reform. As Chris and Tony have said, it really is up to the city at this point as to do they want to be part of the solution here? Because this is a teachable moment for America. I mean, the whole world is watching Minneapolis, Minnesota. The whole world is watching the leadership. Their political legacies are going to be defined by how they showed and demonstrated responsible leadership on this horrific death. And so when you think about the precedents that were set with the Diamond case and other cases, we know that this is an unprecedented case, And we, with this lawsuit, do want to set a precedent to make it financially prohibitive, that the police won't kill marginalized people and black people in the future in America. And so we have to try to make it financially disadvantaged. Forgive me. I want to say something very clear here. We want to disincentivize them financially to do their job of training the officers, because the hashtags are happening so fast in America that we can't keep up with them.
Okay, Linda, excuse me, let me start with you. I'm going to leave, again, trying the case in the court of public opinion, whether a judge is going to decide to put gag orders on this. I will agree with these attorneys, having been a former civil rights litigator, with respect to the substance of everything they said, especially Chris Stewart, when he indicates that it's unfortunate that many times, unless the case has a lot of notoriety, it can linger for years and years and years. It's like, I used to call it a legal exorcism, trying a 42 U.S.C. 1983 civil rights case. Oftentimes, the government wouldn't comply with record requests, and you have to be in motions 20, 30 times in order to get that information. But when the specter of the public spotlight comes on and people are worried about their careers and how it looks, it definitely speeds up the process and increases the amount of damages. This could all be solved if we had more transparency in lawyers being able to get these records. So what are your thoughts overall about the press conference? And with regard to Mr. Crump, Linda, I got to say, putting it right in the face of the politicians, saying, if you don't give us the financial incentives in order to stop this conduct, your career is on the line. Is that on the line, appropriate or not?
That's exactly That's what's happening, Bob, because you and I both know, and having tried these cases, you're absolutely right. You can't get discovery, right? You go in 10 times, the judge doesn't order it. And the judges are at fault too because they don't order it and they don't put timelines on it, you know? But when they do, as you see in some cases, when you get a case where a judge does it and says, hey, look, you know, you're going to trial. Hey, look, there's going to be punitive damages going to the jury. Hey, look, you know, the insurance policy is not going to cover you, individual officer, for doing what you did. You see that it's the financial incentive and the disincentivization that does work because it's all about money, and that's what it comes down to. And it's sad, it's wrong, and we're going to have to acknowledge it. That right now, that if it costs so very much, that people are going to look up and say, "Hey, my tax rate may go up, so let's do something about it."
So, Mike, what are your thoughts about how Linda is positioning this? And can you go in your own mind a little bit? And here's where the big issue is. It's not a question of if, but when they're going to settle this case and for how much. How do you go about evaluating how much in a case like this? Because just before you answer that, I want the audience to understand that in the end, even if the jury finds the police violated the civil rights statute, they're only allowed to give the amount of damages that they believe is appropriate based upon, a number of factors. How do you evaluate the value of a case?
Well, there are many ways. I mean, you really got to, it's like everything else. You got to start with the basics. It's future earnings, what someone earned in the past, people dependent on that person, the amount of time suffering. That's the biggest one here is this wasn't an instantaneous death. So there was pain and suffering up until the death, things of that nature. And then the most important in the civil rights is in the civil rights action under 1983 action is the amount of punitive damages, and also not to mention attorney's fees. I mean, I always give credit to plaintiffs' attorneys in civil rights actions because they are basically fighting the giant. The municipality has a attorney representing them. The police department has an attorney representing them. Each police officer has someone representing them individually. You get actually inundated. Sometimes they don't give you any discovery, or sometimes they put boxes upon boxes upon boxes upon you just so you have to spend day upon day looking for relevant evidence.
Yeah, and Mike, actually, I think that you were working with me on a case many years ago that literally a 1983 action, it took 10 years, Linda, to eventually wind its way through the court system and a trial with us being stopped every step of the way. And I wonder if there were a bunch of press microphones in front of me and us yelling and screaming, whether people would have paid attention and gotten to the place quicker, as Mr. Stewart indicates, and settled a case that clearly was a violation. And that's the other thing that bothered me in that area. Many times the facts clearly established a violation, yet they didn't even come to the table and settle. They knew they could break your back, or tried to, by having the resources to just keep throwing stuff at you and make you feel the pain before they would ultimately get the settlement, which usually happened at trial or during trial.
Yeah, and make no mistake about it, Bob. The system is balanced. Shall I say? I won't say imbalanced, I guess, against the plaintiffs in these kind of cases, and you know it, and I know it, because after you get the verdict, there's a motion to reduce the verdict, and then some of the judges will do that because they say it's a municipality, therefore the taxpayer shouldn't be hurt. If you get the verdict, you go on appeal and then appeal again. So it will be 10, 12 years. And we've all handled these cases that have taken that. And all they should have been done is evaluated and resolved early, and changes made in policies. And that would have prevented the next case from coming along that would have taken 10 or 12 years, or a death that was unnecessary.
Yeah, and Linda, it's such a great point. And even in those cases where we were successful, got either settlement and or a trial, it was always amazing to me that the policies never changed. So the lawsuit for the next victim came the year after that, and it just made it a lot easier to prove the case, although it was still an exorcism. Guys, love the commentary of these folks. Please stay with us. We're going to take a quick break. We'll be right back.
He's being held now, no bail, in the Eastern District of New York and in the Northern District of Illinois. Unless Mr. Greenberg can convince both of those courts that he should be released on bond, Mr. Kelly's going to remain in custody. So as far as a motion to increase the bond, I don't believe it's appropriate at this particular point in time. That being said, if there's a change in circumstances, in other words, if you're able to convince both of those federal courts in those different jurisdictions that he should be released on bond or some type of conditions regarding release, if you want to bring that motion to increase the bond back before the court, I think that would be appropriate. But at this particular time, it's kind of a moot point. The bond that was set originally in this matter by the, I'm assuming the bond court judge, or maybe from the grand jury, I'm not sure. Bond court? Okay. I thought when the case first came before me for arraignment that the bond was adequate based upon the fact that there's 4 cases, there's $250,000 D bond on each one of the cases, plus pretrial services, which I thought was appropriate based upon the information that I had regarding Mr. Kelly. I still believe that's true. That being said, I'm going to deny the motion at this particular point in time. If there's a change in circumstances and he is somehow released from custody and you want to bring it back before me, I'll take a look at it then, okay?
All right, this all was precipitated by the fact that R. Kelly was assaulted by an inmate. There was a dispute. He had received only minor injuries, and from what I'm being advised from reading the news accounts of this, is now in segregation for his protection, and that's what precipitated this motion. Linda, you know, real serious charges here, multiple jurisdictions. Right. The likelihood of him being bonded out is not likely, and he's not the only person that is in protective custody in the prison system. So where were they going with this?
Well, you know, you're going to keep a record. You're going to keep at it because maybe the next assault is worse, right, Bob? And also, there are also claims against the jail if you are an inmate that is pre-conviction for not protecting you well. So it's a very interesting thing that his attorneys are doing, and you know, he's got a very smart attorney on his side, but he's not getting out of jail. But they are going to have to watch him, and this puts on notice that he's high profile. He's already been subject to one attack, and the second attack may give some liability for the jail.
You know, Mike, great points that Linda's making in making the record. You know, there's a lot of jail cases that are going on right now where people are asking for compassionate care release because of the COVID-19, and we were just discussing, you know, before when we were off camera, that even New Jersey is proposing that if you're 1 year out from the termination of your sentence, you're given additional credit because being in the jail during COVID with all of the restrictions are considered hard time. In other words, that they should get credit for that because it's worse than it normally is. I was wondering, do you think they're ever going to get to that way with people that are put in segregation for their protection that have done nothing wrong? Because that's really hard time too. People hate segregation. They'd rather go into general pop and take the chance of being assaulted rather than being in seg. What do you think?
I don't know. You know, that's one of those Hobbesian choices. Like, it's which evil are you going to choose? Because as we know, we've all had clients in segregation. I mean, you get 1 hour out of 23 to get out of your cell, to get some air, to exercise, things of that nature. It's just a very difficult position. But, you know, Bob, as we all know, being charged with the offenses that R. Kelly is charged with within the prison's inmate self-policing, for lack of a better term, those are looked upon as very punishable by fellow inmates. Although part of the, I understand, attack that involved Kelly had to do with people blaming him for something to do with COVID, but you just never know what causes the fight. But segregation is tough to get through.
Yeah, and get into another jail case, an inmate who was beaten by prison guards and left paralyzed was recently awarded $4.65 million, one of the largest civil lawsuits against that state in the history. Guys, you know, this unfortunately is another reality that inmates deal with. You know, they have a right to be taken care of. We've seen jail video and jail footage, and I'll tell you, when I was prosecutor, it's even for us sometimes difficult to get information from the jail, but this stuff occurs, and it's so, I know people are gonna think this is strange, but you're the custody of the state, and the state has an obligation to protect you. What are your thoughts about any of this, Linda, about what you see going on in these jails?
Yeah, you know, they beat her because she said she had a hip condition, and believe it, I've had you know, 2 hip replacements, that she couldn't clean the toilet. But then they fractured. I mean, they fractured her neck and her spinal cord, Bob. There's no excuse for that. I have There's another case in Florida that's going to probably settle where an inmate committed suicide. It's Jessica Rogers is the wife for a person, and I can tell you right now, Escano Reyes, where he hung himself after a number of times where he was taunted and he threatened that he was gonna kill himself. You know, we got to start dealing with inmates as people, and then this won't happen. But there's simply no excuse to fracture the neck of an inmate. None.
Yeah, and Mike, from what I understand too, and not that it makes it right or wrong ever, these were minor charges that she was in there for, you know, and I've said many times to some prosecutors as a defense lawyer, but I'm thinking of one I had a couple of years ago, the person with a very, very bad medical condition that they just were not able to manage. That the guy on a probationary sentence where he got 364 days in the county jail, being repeatedly sent to the hospital because he was falling into diabetic shock and a coma, shouldn't have to pay for his life for a driving related offense. But nevertheless, on and on we went, and thank God he made it out.
Well, you know, Bob, it just goes back, I think, to the very basics is when people are in charge and responsible for other people's well-being, whether they be convicted criminals, suspected criminals, whatever, it comes down to education and training. It comes down to education and training and responsibility. Listen, being a jail guard, I can imagine, is not the most glorious job. But that doesn't mean you just take anybody who's willing to put on the uniform. If you hire expectations of those people you employ, those expectations are usually met. I think it comes down to training and education.
Yeah, you know, Mike, it does. But Linda, you know, that like to the point you were kind of raising before, this is a woman who's on a minor charges. She said she couldn't clean, I think it was a toilet because she had a hip condition and is now paralyzed for life. I mean, it's just, to me, it's not a training issue. It's a humanity issue.
It's humanity. It's also whether or not other jail inmates or correction inmates have been disciplined and fired or charged as a result of it. Until you start showing that this is not going to happen, and if you do this and you're a corrections officer, you're going to get charged or prosecuted and put away, it's not going to change. Because right now we just say, oh, it was an inmate. Well, let's pay the money and we'll go on to the next case.
Yeah, Mike, to your point before in another segment you were raising, this is a settlement of $4.65 million. And you had indicated that in with the George Floyd case, the amount of time the person was experiencing the trauma of the incident is relevant. And you're right. This woman's got to live with this for the rest of her life. Just a question. Do you think George Floyd, who suffered far less trauma, you know, if you get what I'm saying here, at the hands of police is going to get more than that 4.65?
Well, I think 4.65 is not a great amount for what she was put through. And when she was in the custody of someone else responsible for her well-being, I think that was a very low settlement. And I think George Floyd will be in much higher numbers,
Completely agree with that. Mike, Linda, thanks so much. Always a pleasure. Our regularly scheduled programs coming up. Stay with us. You can find me at Bianchi ESQ on Twitter and Instagram. Have a great week.